morning. Our first case this morning is Fearrington et al. Versus City of Greenville et al. And we will hear from, and I'll note that Justice Dietz is recused in this. We'll hear from the appellant.
Good morning, Your Honors. May it please the Court, my name is Dan Hartzog, Jr., appearing for the appellate City of Greenville in this case. The issue for the Court today is whether the Court of Appeals erred in determining that the interlocal agreement between the City of Greenville and the Pitt County Board of Education violated the Fines and Forfeiture Clause of the North Carolina Constitution, Article 9, Section 7. I think in making the determination of whether the Court of Appeals erred, it's important to remember that we acted in accordance with specific legislation from the General Assembly that adopted a local act allowing the City of Greenville and the Pitt County Board of Education to enter into a cost-sharing agreement and reimbursement agreement to fund the red light camera program. In 2016, the City of Greenville decided they wanted to look at red light cameras within certain intersections of the city to increase safety, increase efficiency with law enforcement cost of enforcing the red light cameras. And one of the considerations that they had to take into account was the cost of running the program. And what they wanted to do was make sure that the Pitt County Board of Education got funding from the program and that they were not operating at a loss, because if they were going to operate at a loss, they weren't going to be able to operate the program. So what they did is they went to the General Assembly and said, we would like to enter into a cost-sharing agreement with the Board of Education so that the Board of Education has some say in how the funding mechanism works. And the General Assembly adopted a local act, House Bill 2016-64, which specifically authorized the city and the Board of Education to enter into an interlocal agreement for the purpose of cost-sharing and reimbursement on the red light camera program. That agreement is, there's no question really that is to the mutual benefit of the city and the Board of Education. The city achieves its purpose of increasing safety, increasing efficiency in operating the red light cameras, and the Pitt County Board of Education, over the brief course of the program, which is not currently running due to this litigation, got roughly $2.5 million in revenue that they would not otherwise have received. That revenue, according to the Board of Education, was used in part to increase safety in the schools, including security cameras, warning system, modern locks, things that the school board desperately needed in today's age.
Was the decision by the Court of Appeals in effect a declaration that the local act is unconstitutional?
I believe so, Your Honor, because what they essentially said is the way that we are operating the program, the way we entered into the interlocal agreement, is a violation of the Fines and Forfeiture Clause. The way we are operating the program and the way we entered into the agreement is exactly what was authorized by the General Assembly in House Bill 2016-64.
So should the Court of Appeals have applied the presumption of constitutionality?
That's our position, Your Honor. Yes, they should have. There is a presumption of constitutionality, and the state was not a party. So the Court of Appeals do not have the jurisdiction to strike down the law as unconstitutional, which is in effect what they did. They said you cannot enter into a cost-sharing agreement because that's a violation of the Fines and Forfeiture Clause. Well, that's exactly what the General Assembly told us we should do, and that's exactly what we did. There's really no argument that we are in violation of 2016-64. The plaintiff's position on that is, well, you can only comply with that by an arrangement where the city gives 90%. At the end of the day, after all the transactions, that the board has 90% of the clear proceeds. What that would mean, in effect, is that the special legislation, the House Bill 2016-64, is superfluous. It's meaningless because we already have the authority to maintain 10% for cost of collection. So if you read House Bill 2016-64 to mean that we can only keep, at the end of the day, the cost of collection up to 10%, that bill is meaningless. It's superfluous, and this court very recently in the a redistricting case said that, you know, the General Assembly is entitled to the presumption of constitutionality. And we don't read, under Bowles v. Oak Island, we don't read a piece of legislation to be meaningless. It has to have some effect. The General Assembly must have had a purpose to adopt that. And the purpose is exactly what we asked the General Assembly for, an agreement by which we can fund this program through a cost-sharing agreement.
Counsel, you used the term earlier, revenue. Is there a difference between generating revenue and collecting a fine or a forfeiture?
Well, yes, fines and forfeiture, you know, for a civil penalty for a violation of a statute, when we collect it, that would be a civil penalty. I use revenue in the sense of just money coming in that we use to fund the program and provide to the Board of Education.
Is there a sort of an active component to generating revenue and a passive component to collecting a fine or forfeiture?
Well, I think, for example, a tax would be sort of a passive revenue. People pay it no matter what, whereas a civil penalty, like we're dealing with here, there's a program that has to be in place where, you know, we've got American Traffic Solution who has installed the camera. They operate the program and issue the fines. We've got an officer who oversees the program. So there is it's a much more active in the sense of we need to, you know, spend money to have the program operate. Whereas a tax is just people pay the tax. So there's a more active in that sense to collect the fine. Yeah.
No, I understand in your situation, but typically when we think of fines that are assessed through court costs and fines and that sort of thing, I mean, that just seems more passive in terms of what a fine would typically be. Why would that be wrong?
Well, I think you're correct in that. The reason this is, and I'm not exactly sure the distinction here between active and passive, but there is, you know, money that needs to be spent for this program to operate correctly. We have to, you know, whereas court costs, you know, you send someone the thing and they say, okay, you got to pay the court cost, and they just go pay it at the window. Whereas here, there's a whole appeal process. There's a ticket that gets issued. People have the right to contest it. There's an administrative hearing. They have the right to appeal that up to the Superior Court. So operating that program does cost money. And that's exactly why we went to the legislature to give us the authority to enter into this cost-sharing agreement. And I want to make the distinction here between...
Let me ask, sorry to interrupt, but
No.
Are there other areas of the state that have similar programs? In other words, how much impact will our decision in this case have on the other places that have this program, if there are others?
Currently, the city of Fayetteville also has a very similar cost-sharing program. In fact, the city of Greenville was modeled on the city of Fayetteville.
What about other municipalities? How do they fund theirs?
Well, the city of Concord and Wake County have red light cameras where they, you know, they've got special legislation that allows them to keep money on the front end for cost of enforcement. So that's one other system that the General Assembly has come up with to allow these programs to continue. Some do operate at a loss. But I think, you know, in the interest of allowing municipalities to operate these programs, which again has funded Pitt County Board of Education to the tune of approximately $2.5 million over the brief period of time that this red light camera system was operating, that is a model that other municipalities should use, I believe, to fund the schools. This is a massive benefit to Pitt County Board of Education, and they've got funds that they wouldn't otherwise have. And that distinguishes this case as well from, you know, the Shavitz case and some of the other cases where the court said you can't keep the money on the front end. What we did here, we're not keeping money, we're not diverting money away from the school. We've created a system that brings more money in that wouldn't otherwise have existed. So because the city of Greenville got this agreement with Pitt County through the General Assembly, we've created a program that increases revenue to the Board of Education that wouldn't otherwise even exist. So the city wouldn't have this revenue to give to Pitt County Board of Education if not for this agreement. So that's distinguishing this case from Shavitz, where, you know, High Point kept the money on the front end, never gave it to the Board of Education. The Board of Education was the one coming into court saying, hey, you're not giving us the clear proceeds of this. And the court rightfully said, yeah, you're in that situation where the city's keeping the money, never gets to the Board of Education, that's a violation. Here, there's no question, the money does get to the Board of Education. They get 100% of the proceeds on the front end. It goes into their general fund. Out of their general fund, they're invoiced each month for the cost of operating the program. It's about $30 per ticket and the cost of having an officer to oversee the program with the city. And they can use the funds that they've received from the fines and forfeiture, from the civil penalties, or they can spend money that they have otherwise obtained from anywhere. Anything in their general fund that they could spend on funding this program. So what the Court of Appeals erred in, I believe, is looking at this as a single transaction, whereas really what you should be looking at is, does the money collected from the tickets make it to the Board of Education? 100% of it does. The Board of Education then has the right to decide how they want to spend the money, and the Board of Education gets deference in how they spend their funds. If they choose to use the money collected from these fines, they can do that. If they choose to spend other money on operating the program, they can do that. And again, that's specifically authorized by the General Assembly in 2016-64. It's saying, yes, Board of Education, you can spend your funds on operating this program, helping to fund this program, because it's a benefit to the schools. It gets them millions of dollars in revenue that they would not otherwise have. If this court were to uphold the Court of Appeals opinion, the Pitt County Board of Education would have less money as a result. That is a perversion of what the fines and forfeiture clause is intended to do, which is to increase funding to the schools and make sure they are well funded. This program, again, specifically authorized, specifically contemplated by the General Assembly, helps fund the Board of Education, helps give money to the schools.
I'm assuming that what you've just told us is your theory of how to navigate the Cobble cases from this court.
Correct, Your Honor, because the Cobble case determined what can be withheld from the Board of Education on the front end. What do you have to pay the school? What can you hold back for the city? What we do here is the city is giving all of the money to the Board of Education. The Board of Education is making its own independent determination, which the General Assembly has authorized, that you have the right to enter into it freely and, you know, arm's length negotiation, Pitt County Board of Education, City of Greenville, sit down at the table, see if you can come up with a way that both of y'all like to, you know, fund this program. And again, it's to the benefit of both sides. The city benefits by having the red light cameras, increasing safety. Pitt County Board of Education benefits by receiving millions of dollars that they would not otherwise have.
Just following up on Cobble, if we don't agree with the first part of your answer, that is, if we say, well, that's just sort of a contractual workaround, and in fact what we have to look at is what ultimately the school board gets to keep from this program. Because if they didn't get the funds initially, they wouldn't have the expense that they're paying back for the collection and enforcement. And so my question is, Cobble doesn't say what the constitutional, it doesn't say, for example, that the constitutional provision has a 10% limit on what it simply says the test for determining permissible deductions must bear a reasonable relation. And so is there any reason why the General Assembly any reason why it offends the state constitution for the General Assembly in its local bill to decide what costs bear a reasonable relationship?
No, Your Honor. In fact, the court has specifically recognized that the General Assembly, that the fines and forfeiture clause is not self-executing, that the General Assembly is the one who determines how the fines and forfeiture clause is to be accomplished, the goals of the fines and forfeiture clause. For example, in the Concord and Wake County local legislation, they've said you can satisfy the fines and forfeiture clause by keeping some of the collection cost. Here, they said you can satisfy the fines and forfeiture clause by entering into a cost-sharing agreement, a reimbursement agreement. So the General Assembly has a role in determining how the fines and forfeiture clause is to be executed. And that's what they've done here. They've determined that we can comply with the fines and forfeiture clause. You have to assume that their legislation is constitutional by entering into this cost-sharing agreement. And I'll add, too, that under Article 9, Section 2 of the North Carolina Constitution, the General Assembly also has the right to assign units of local government responsibility for the financial support of schools. So the General Assembly has a right not only under the Fines and Forfeiture Clause, but under Article 9, Section 2, to allow the city of Greenville to operate this program because it increases funding to the schools. The schools have more money as a result of this program than they would otherwise have. And it's not a situation where we are diverting funds from the school board to our own purposes or to some private corporation, as the plaintiffs like to argue. This is money that would not exist absent this agreement. So this agreement creates revenue that would not otherwise exist that goes to the school board.
To what extent does Boney tell us that we should look at whether the constitutional objective is being satisfied and not get wrapped up in formalism?
Well, I think you do look at whether the constitutional objective is satisfied, and it is. The constitutional objective, as the court has held, is to fund the schools and make sure that money is not diverted. Again, money's not being diverted. Money's being created that would not otherwise exist. Revenue comes in that wouldn't otherwise exist that goes to the school board. And the way that works is exactly how the legislature told us we should do it, which is enter into this cost-sharing agreement. If I may, Your Honors, I'd like to reserve some time for the Board of Education to argue and reserve 5 minutes for rebuttal.
Thank you.
Thank you.
Good morning, and may it please the court. My name is Robert King. I'm here on behalf of the Pitt County Board of Education. I'm joined at council table by my friend and partner, Elizabeth Troutman, also joined by Ms. Emma Hodson, who is the Board of Education attorney. I want to talk briefly about standing, but I want to address two things briefly on the merits before we go to that. First, to be clear, plaintiffs are not here to help the schools. They're invoking Article 9, Section 7, but their goal in filing this lawsuit is to shut down the red light camera program. If they can put some money in their own pockets, they will do that, and that's what they're trying to do under Article 9, Section 7. But what they want to do is take Article 9, Section 7, that from its beginning has been used exclusively to fund the schools. They want to take Article 9, Section 7, turn it into a weapon, and take money away from the schools and put it in the pockets of people that broke the law and endangered the public. That's what this comes down to. Second, this red light camera program should be, and it was, a win-win situation. We had safer streets, that is undisputed. We had more money for the schools, that was undisputed. The problem is you can't run a red light camera program just taking 10% for enforcement. A couple of different ways you can do it. The General Assembly has said with Concord, you take the money of enforcement out on the front end. In this situation, the city said to us, how about helping us with this red light camera cost? We can't run it with just 10 cents on the dollar. And we said, we would be happy to do that. We're desperate for money, but we don't want anybody thinking we're being sneaky. We don't want anybody thinking we got fancy lawyers behind closed doors trying to get money that they shouldn't be getting. So we did the right thing. We put this out in the sunlight, and we said, we're going to go to the General Assembly, and we're going to say to the General Assembly, will you please give us the authority to voluntarily enter into a contract pursuant to which we reimburse the city for the cost of this program, and that's exactly what happened. The fact that this is authorized by a local act, that this is an act from the General Assembly, is not mentioned by the Court of Appeals in that portion of the opinion, and I think they just missed that. It was a fairly complicated case, so I certainly don't fault them for that. There is no dispute that the General Assembly specifically authorized to do exactly what we did. There is no dispute about the fact that the city and the Board of Education voluntarily entered into this contract. There is no dispute about the fact that the parties complied with the contract that was entered into. As my friend and colleague said, Article 9, Section 7 is not self-executing. It's not simply a situation in which the General Assembly is entitled to some amount of deference. They're entitled to a lot of deference because Article 9, Section 7 sets a goal in the Constitution, but it does not tell you how to reach that goal. The General Assembly has to do that. We went to the General Assembly so that they could do that. On the question of standing, the plaintiffs could have gotten to the standing in this case two different ways, and they didn't do it either way. The first is by showing that their own legal rights, in this case their constitutional rights, were violated, a Quorum Act claim. The problem for the plaintiffs in that is that the violation that they claim happened is Article 9, Section 7. Well, Article 9, Section 7 is only for the Board of Education. Every case that has ever been argued prior to this case under Article 9, Section 7, the aggrieved party was the Board of Education because it can only be the Board of Education. The idea that you can use Article 9, Section 7 as a hammer to pry money out of the schools and put it in the pockets of people that are scofflaws is not sensible. They do not have a constitutional claim because they do not have a constitutional right under Article 9, Section 7. The second route is taxpayer. Court has referred to Cobble. Cobble is a completely different situation. Cobble, Shavitz, Moore are a long line of cases in which local units of government and sometimes the state said, you know, we really don't want to give fines and forfeitures to the school board. We're going to find a way to get around that. This is the opposite of that situation. I hate to be blunt about it. Article 9, Section 7 is our money. That's what the founder said. It is the money that goes to the schools. And the idea that you can use Article 9, Section 7 to take money away from the education of children and give it to people who run red lights is as twisted a use as you could possibly get.
Just
Yes,
one
Sharon.
quick question on taxpayer standing. You didn't mention Goldston, and that's the case where we said that there's taxpayers have standing to challenge unlawful or unconstitutional government expenditures.
You were exactly right, Your Honor. And I was actually coming to Goldston. I appreciate the court getting there. I got myself distracted. The idea behind Goldston and taxpayer cases, well, first of all, they haven't brought a taxpayer case. A taxpayer standing case is one in which you say, the Board of Education is not being treated fairly, and we're going to stand in the shoes of the Board of Education, and we're going to get that money for the schools. That's what they did in Cobble. In Cobble, they said that money needs to go to the schools. They weren't trying, the plaintiff in that case was not trying to put the money in their pockets. Same thing in Shavitz. Henry Shavitz sued the Board of Education. I was counsel in that case. Sued the Board of Education and sued the city of High Point in an action to get the money into the hands of the school. These folks don't want the money to go to the school.
But that's about relief. That's about the relief they're seeking rather than do they have standing to bring can they get a declaratory judgment?
Well, I'm not sure that you can tear those apart, Your Honor, because a taxpayer action is an action in which you're acting in the public good. That is per se in the public good. It's not private relief, it is public relief on behalf of the public or on behalf of a public entity. These folks are not seeking public relief. If they brought an Article 9, Section 7 case and said that the Board of Education is being cheated and they want a declaration that the money needs, that would be a taxpayer case. Now let me say this about taxpayer actions as well. Taxpayer actions are actions in equity. Equity rules apply, which means the first step, if you want to be a plaintiff in an equity action, is you come into the court with clean hands. These folks are only here because they broke the law and endangered the public. They do not come here with clean hands. If you're coming into a court of equity and you're asking for equitable relief, you have to be wanting to do equity. These folks are not wanting to do equity. They are wanting to take something that benefits the schools, to take money away from the schools and put it into their pockets only by virtue of the fact that they broke the law.
So would you agree that if these plaintiffs, whether or not they actually had to pay a fine, but they simply came in to say, Board of Education, we believe that you are misspending money, could they then have standing?
I think if they were genuinely acting as if this was a taxpayer suit, I think they would have standing, Your Honor. Now, the fact that they're fine payers or they're paying money because they broke the law, I think it makes it difficult for them to be taxpayers, because the underlying idea under Goldston was that I'm paying money to the DOT so that DOT can improve my roads. So I'm going to get a benefit of the taxes I'm paying. These folks didn't pay fines to benefit them. They're paying fines to punish them. And the idea that you break the law, endanger the public, and then you get to sue the schools and take money away from the schools is not something that Goldston or any case I would submit in the history of jurisprudence has ever said.
And sir, sorry, Chief.
No, go ahead.
Before you leave this, would you comment how let's see, 115C44 statute, how it interplays with the argument you're making.
Can you remind me what that says, Your Honor?
Sure. This is the one that says a local Board of Education shall institute all action, suits, and proceedings against officers, persons, and corporations. And it really dovetails in, I believe, to the argument you're making as to who's the proper party here to bring such a suit.
Well, and I think it also goes to Justice Allen's comment before, which is, don't look at the form, look at the substance. What is it that we're trying to accomplish here? You look at the Boney case or the Bonnie case. I have Bonies in my family, so we pronounce it Bonnie. What that said is, look, if they gave away an $8,500 piece of property, the Board of Education did in that case, that can't be right. And this court said, no, let's step back and see what's going on here. They spent $8,500, they got $150,000 back. Here, we're spending money, but what we're doing is we're saying, we'll give you 31 cents and we get back $1. We are making money, and then we take that money and we educate the children. I'll tell you one thing that distinguishes this case from every other case is that the Board of Education agrees with this. I have never seen an Article 9, Section 7 case where the aggrieved party was anybody other than the Board of Education, because Article 9, Section 7 exists only for the benefit of the Board of Education.
I just want to be clear that I
Yes, sir.
understand your standing argument. Are you saying that because they had to pay penalties for violating or for violating the ordinance that they can't have taxpayer standing, period? Or are you saying that they could have taxpayer standing if they weren't seeking the return of the penalties they paid?
I think more the second, Your Honor. I think that if they came into this court and said, okay, we paid these fines and forfeitures because we broke the law, but we want the money to go to the schools, they got a pretty good argument for standing in that situation. That's not what they're doing. I don't want to lose track of the merits here, because the merits are, and the thing that I want to bring the court back to is, we went to the General Assembly because the General Assembly tells us how Article 9, Section 7 works. And the General Assembly said, not just share money with the city. What they said was, you can reimburse the city for the cost of running a red light camera program. If anybody acted unconstitutionally here, it was the General Assembly. And the General Assembly didn't act unconstitutionally, because this is the job of the General Assembly. Last thing I want to say is, there is a provision in the Court of Appeals decision that says that Article 9, Section 7 places restrictions on how the Board of Education spends money. That is very wrong. First of all, it was not pled. There is no precedent for that idea. And the Board of Education, I mean, we're not cowboys out there spending money the way we want to spend money. The General Assembly and DPI and the State Board of Education tell the schools all the time what to do. They not only tell us how to spend the money, they tell us how to account for the money. There's a statute from the General Assembly that tells us how big the no parking signs have to be. So it's not that I'm saying that the Board of Education is not subject to oversight from the General Assembly. They're already subject to oversight from the General Assembly. Imagine if Johnny Taxpayer could walk into this court and say, I don't like the number of paper clips you're buying. I don't like what you're paying the cafeteria workers. You shouldn't be buying security cameras. That's what the plaintiffs are saying they have the right to do. I am happy to answer further questions. I did promise Mr. Hartzog that I would leave him 2 minutes and 3 seconds. Thank you, Your Honor.
Thank you, counsel. We'll hear from the appellee.
Chief Justice Newby and Associate Justices, may it please the court. I'm Paul Stam for the plaintiffs, and my colleague Dan Gibson will take the last 20 minutes or so to go through the record and detail on the law. I'd like to first answer the two questions that were asked originally. Justice Newby asked what other jurisdictions are doing this. There are two, Raleigh, not Wake County, Raleigh and Wilmington. Fayetteville stopped years ago, 2 years ago. If Concord ever did it, I'm not aware of it. Second question, Justice Allen, is there should be a presumption of constitutionality here. We did not plead. The Court of Appeals did not say that the local bill was unconstitutional. There was a facial challenge in a related case, Vitovas versus City of Greenville, in which Greenville and Pitt County said That was not an unconstitutional local bill relating to health because it had nothing to do with health. Here they're arguing that it's all about safety. Interesting. I don't have to go to the brief to explain that their big picture is that we're scofflaws who broke the law and endangered the public. We saw that in their reply briefs and made a motion to supplement the record, which the court declined. And if the court wants to look at that again, they'll see something different. First, if our clients pay a penalty of $100 and get it back several years later, how are they profiting? Second, they're not wrongdoers, much less criminals. The uncontradicted evidence is that 80 to 90% of those receiving citations in Greenville were innocent of violating the criminal statute, and they've accused us of being criminals as well in their reply briefs, which requires mens rea of willfulness. The AOC form charging running through a stoplight says willfully. What is willful? It's been defined by this court dozens of times as intentionally and without justification or excuse. Mr. Ceccarelli, an engineer and the only qualified to present evidence, explained all this in detail to the trial court. This is at the Court of Appeals, paragraph 51. We are not asking you to reverse your denial of our petition for discretionary review concerning the unusual physics exploited by Greenville, but we highly object to our clients being referred to as profiteering wrongdoers or criminals.
Can I move past the language and names being used and just,
Yes.
I understand that the recovery in a taxpayer suit accrues to the local government supported by the taxpayers. So regardless of whether you call this recovery or profiteering, what case are you relying on to allow this kind of relief?
Our only claim to standing is not taxpayer standing. We have several others. These people paid fines or civil penalties. That gives them standing all by itself. Mr. Gibson will be discussing standing in greater detail. Now, Judge Griffin did conclude that this was a strict liability civil penalty, and for purposes today, so be it. But that does not mean that any of the tens of thousands of drivers who received citations from Greenville willfully violated this statute. Third, we object to Greenville and the board trying to create two different transactions of what the Court of Appeals said was an interdependent single transaction. Imagine if I tried to defend usury by having the debtor sign a note to me within the legal interest rates, but I wouldn't give him the loan if he did not agree to give me my lending business a country ham every Christmas, New Year's, and Thanksgiving. Perhaps each of you will borrow money for a home or an investment, and at closing, you'll see a truth in lending statement under Regulation Z. Your true interest rate on the amount actually financed is shown in economic terms. No artifice is allowed to distort economic reality under pain of severe consequences for the lender and maybe the closing attorney. We have laws against video poker and internet cafes. The ingenuity of those who deceive others to part with their money is frequently deployed, but 3 times this court has unanimously seen through these schemes and said no. In economic terms, there's no doubt that the school system of Pitt County is paying the enforcement cost, and in their argument they confuse collection costs and enforcement costs, that are incurred by the agreements with ATS and between Greenville and the Board of Education. And you'll see through these schemes, I believe. Let me say a word about the two amicus briefs.
But before you do that, what about the fundamental point that if this agreement is struck down, the outcome won't be more money to the schools, it will be less money to the schools, and that's contrary to the purpose behind Article 9, Section 7?
Well, Justice Allen, that's not the only purpose of Article 9, Section 7, which is addressed in great detail in Part 1 of the Civil Liberties Union brief, which addresses the problems with policing for profit and addresses something raised by Justice Newby in a dissent a few years ago. What's the problem with a regulator getting part of the money? Let me address it further on that point, something you raised, whether there should be a presumption of constitutionality. It is a logical fallacy to say that just because the General Assembly approved cost sharing, which would include both enforcement and collection, that therefore it is legal to apply that local bill by having a division of money that is completely contrary to the statute. I believe it's 115C 437. The General Assembly did not say that, you can put the enforcement costs, all of those, onto the school system. Or if I could just, if that sufficiently answers, I'll just mention two last things. The Civil Liberties Union brief, Part 2, is a typical Brandeis brief, with all the problems that will come if you reverse this. And that's not really before you. And even if it's true that these civil penalties are highly regressive and discriminatory, that's not really before you. But Part 1 of their brief does show how Article 9, Section 7 should be interpreted as addressing also the problem of policing for profit. Just to give you one example, Greenville tries to justify how important public safety is, even though in the Faitova's case they said it had nothing to do with safety. But the city of Greenville is not willing to put money into it at all. And you would think that if Greenville was interested in public safety, they would be willing to spend a little money on it. But no, they found a scheme to put all the costs elsewhere. The brief for the North Institute for Constitutional Law is also well worth a read. It elaborates in even greater detail how Greenville-Pitt County Board of Education scheme with the for-profit Arizona Corporation violates our Constitution and our statute. I'll defer to Mr. Gibson at this point unless there's another specific question for me, but he's smarter and younger.
I'm certainly younger. I don't know about smarter. May it please the court, I'm Dan Gibson. I represent the appellees, Eric Fearrington and Craig Malmrose in this case. The citizens have a right to challenge the unconstitutional use of money the state obtains from them. That fairly bland proposition is the bedrock of this case. There are three reasons why you should affirm the Court of Appeals here. First of all, everyone agrees at least a portion of this money is being used for purposes other than maintaining free public education. Secondly, this court's standing cases make it clear that a citizen can sue to restrain the unlawful use of public funds to his detriment. Third, a court has already held that Eric Fearrington exhausted his administrative remedies. Even assuming he had to exhaust his administrative remedies, he did it. He went to the Pitt County Superior Court and got an order that concluded as a matter of law he had exhausted his administrative remedies. And that order has never been appealed. It's binding in this case. On the funding issue, There are multiple purposes for Article 9, Section 7, as this case recognized in this court recognized in Cauble. In Cauble, this court said that one of the purposes is to prevent the diversion of funds from public education. Diversion such as paying a private for-profit corporation in Arizona to run a red light camera program. I respect that the Board of Education has discretion in how it spends its funds for educational purposes. For example, in the Boney case, they made an agreement to essentially share a public park with Kinston-graded schools. Kinston-graded schools could use it on certain occasions for, I believe, a professional, I think it was a minor league baseball team. But at all other times, it was a park that could be used for educational purposes for the citizens and students of Kinston-graded schools. The court in Boney was at pains to say that physical education is part of education. It's part of building the whole student. We don't just build the mind, we also build the body.
Let's say that the schools believed that there was a problem with individuals passing a stopped school bus with the sign out. And so they found a group that would put cameras on the school buses when the stop sign went out that could record individuals who then passed the stopped school bus. And the school board paid for a group to install those cameras and also to provide information about the license numbers of the cars that passed the school bus. Would that be a valid expense of the Board of Education?
I think it would be, because it still has an educational purpose. What we're really objecting to here is funds being used, as the Constitution says, for purposes other than maintaining a free system of public schools. The reason why the Board of Education spends money on school buses is so that students can get to schools and students can get to schools safely. So as long as the purpose has some substantial or substantive relation to education, that's fine. But red light cameras all over the city of Greenville have no educational purpose, and they haven't argued that they have an educational purpose. Their only argument here is, well, we get more money. One, that's simply not true. If they got the clear proceeds, 90% is more than 70%.
But the constitutional provision doesn't say fines and fees collected from activities that relate to education. It says the state constitution was intended to provide for funds for public education from any violation. So we've had cases about parking violations.
That's correct. And I'm not saying that the educational limitation is on the collection side. It's on the spending side. So Article 9, Section 7 says, the clear proceeds of all civil penalties shall be faithfully appropriated and, this is the second part, be used exclusively for maintaining a free system of public education. That second part, well, we'd contend either way you break this argument down, either it's not being faithfully appropriated to the Board of Education to be used for education, or it's not actually being used for education by the Board of Education. So
how do you get to your remedy if that's the problem? Is that it's not unconstitutional to put up these for civil enforcement, the cameras. It's not unconstitutional for people to have to pay fines, but what you're alleging is unconstitutional is simply the payment of 32% as opposed to 10%. Why is that remedy then? So anybody who had to pay a fine, then gets their money back?
So the specific remedy that we're seeking here is a declaration that the program as applied violates Article 9, Section 7. That, in other words, the Board of Education's action here is ultra vires, and that relates to the standing doctrine. All of the demand cases that appellants cite also say, Daughters of the Confederacy, I think, makes this the most clear. You can either allege that you're filing an action on or behalf of the city or the county, or accuse public officials of misuse or misappropriation of public funds. We're proceeding under that second route. So if this program is ultra vires because it exceeds the city and the Board of Education's authority under Article 9, Section 7, then there needs to be a declaration that the whole program is unconstitutional, was void ab initio, And the funds should go back to the people that they were taken from, because they remain our clients' money if they were unconstitutionally taken from our clients.
So if we don't agree that the program was void ab initio, does that mean that we should dismiss?
I don't think so, because the standing issue, I don't think, is tied to whether the program is void from the very beginning. The standing issue is tied to whether or not this is an unconstitutional use of public funds.
Are there any scenarios where the local bill would not be unconstitutional from your perspective?
This local bill?
Yes.
If the city and Greenville had entered into a cost-sharing arrangement where they were otherwise complying with 115C 437, because this local bill doesn't create an exception.
Well, what if we say it does?
If it does create an exception, then it still runs into the problem of the holdings in Cobble, in Shavitz, and in Shore.
Well, my question is there any way that the local bill, as it's stated, would be constitutional?
If they had implemented the local bill in such a way that the Board of Education was not paying enforcement costs, and one of the chief enforcement costs here is that the Board of Education is paying Officer O'Callaghan's salary. He's the hearing officer, he's the officer that's reviewing these red light camera citations. Under Shavitz held that that was an enforcement cost.
So if we took out the officer's salary, would it then be constitutional?
I think it would be a closer question. We'd have to look at the specific invoicing from American Traffic Solutions and decide whether those are costs of collection or costs of enforcement. I think some of those would almost certainly be costs of enforcement. So, for example, the cost of simply operating the red light cameras themselves is almost certainly an enforcement cost, whereas something like the cost of mailing a citation, perhaps even the cost of the administrative hearing itself could arguably be a cost of collection. We haven't really gotten into the nitty-gritty of that here because the defendant's argument has been, well, we can do whatever we want to with this money as long as we voluntarily agree to it.
So you would agree that if we say this program is not void ab initio, then the relief that you're requesting would not be available?
I think relief would be a question for the trial court on remand because there was no relief granted to our clients in this case. There was simply an order dismissing our claims and granting summary judgment to the defendants.
Well, but there was the Court of Appeals that said grant summary judgment to your clients. To me, that would say also refund all the money because summary judgment says your claims are valid. And the only relief, well, you've asked for relief with regard to the declaration, but you also are asking the relief to be a class that receives refunds of all the monies that have been paid.
So that motion for class certification hadn't been heard before the motions to dismiss and motion for summary judgment. We came to an agreement with appellant's counsel on that issue because the issues were primarily legal issues in this case, including the Article 9 issue. So I think there would be more work for the trial court to do on remand.
Well, what do you think granting summary judgment means?
I think on this particular claim, what we're arguing here is really the liability issue on Article 9, Section 7.
Liability being how the money gets...
Being the underlying declaration that the program itself is unconstitutional.
So that gets back to the void ab initio.
I think regardless of whether, it could be void ab initio, it could be unconstitutional today, it could have been unconstitutional in terms of how they specifically implement it. And that's really our argument, that it is unconstitutional in the specific implementation in this case. And that goes to the funding issue. That they've argued that this lawsuit would deprive the Board of Education of funding, prevent this red light camera program, so on and so forth. That result does not necessarily follow from a holding in our favor.
I want to make sure that I understand your argument about the relationship between the local act and 115C-437. Are you, I think what you're saying is that it's fine to have a cost-sharing agreement under the local act, but it has to comply with 115C-437, correct?
That's correct, because the local act doesn't create an exception to 115-437. It just says a cost-sharing agreement.
So I agree with you that if the General Assembly's intent was to authorize something at odds with 115C-437, it would have been helpful for them to have included some language to that effect in the local act. One issue, though, I have with reading the local act the way you want us to read it is that Chapter 160A already gives local governments the authority to enter into interlocal agreements to effectuate any lawful purpose and allows cost sharing, for example. So I'm struggling to see why the local act would be needed at all if that was the General Assembly's intent.
So the reason why a local act would be needed lies in 160A-300.1, which is the specific authorization for traffic control photographic systems in municipalities. The last subsection of that bill, subsection D, this section applies only to the cities of Albemarle, so on and so forth. It lists a number of municipalities that are authorized to have red light camera programs. And the session law at issue in this case, 2016-64, added the city of Greenville to that list. So if there wasn't this particular local bill, Greenville wouldn't be authorized under 160A-300.1 to enter into a red light camera program.
But it wouldn't have to have the provisions on cost share or the provision on cost sharing, would it? I mean, it would simply if it authorized the program, then you could fall back on the interlocal agreement provisions in 160A.
I think perhaps you could. The issue, so it's an interesting question whether or not the 90% number is necessarily baked into the constitutional formula. I think the General Assembly has some degree of latitude there. There's two issues with giving the General Assembly or the Board of Education sort of unfettered discretion there. One, this court's already said costs of enforcement cannot be deducted. You can deduct costs of collection, but the Constitution prevents costs of enforcement. So if the General Assembly says the Pitt County Board of Education can enter into an interlocal agreement whereby it agrees to pay all of the costs of enforcement, that would, under this court's precedents in Cobble and Shore, would violate the state constitution. The second issue
But you also can't, as a general rule, just give away school property. But yet in Boney, we look past that particular issue at what the agreement was going to accomplish. So why shouldn't we look at this in the same way?
Well, I think we can certainly look at what the agreement's going to accomplish, but there's no argument here that what the agreement is going to accomplish is an educational related purpose. What the agreement accomplishes here is a red light camera program that's paid in part by the Pitt County Board of Education. That's the difference between this and putting cameras on school buses to ensure that students can safely go to school. It's the difference between this and Boney, where you're sharing a public park. So, 9 to 5 during school hours, it's a park for school students. Outside of that, it's a park for the city.
But in both, what the school system is getting is resources that it otherwise wouldn't have.
I think how it uses those resources under this court's precedent and under the plain language of the state constitution matters. The school can't just spend its money under Article 9, Section 7 on whatever it wants to. The Constitution appropriates that money and says it has to be used for maintaining a free system of public education. And that follows from this court's holding as well in Cobble, where they said one of the purposes is to prevent the diversion of public funds.
So is there any contention that the revenue that's left to the school system after it reimburses the city, that's not being used for an educational?
The 76% that they're keeping?
Right.
No, there's not a contention on that. I don't know that there was specific discovery on what they were using that money for, but the problem is the deduction of both enforcement costs and more than the 90% that 115-437 requires. So just to be clear, there's two parts of that. One is 437 says 90%. Two is the state constitution says you can't pay a penny of enforcement costs. Even if it's less than 10%, enforcement costs are not deducted from civil penalties under Article 9, Section 7.
Counselor, I'd like to draw your attention to the statute that I mentioned to your friend on the other side, the 115C44, and their argument that somehow your client should have brought this more in a derivative type action as opposed to directly to their benefit. Can you comment about that?
Sure. I think the case that explains that difference the best, and this is cited later on in Goldston, is Merriman versus Southern Paving. It's a decision from this court in 1906. The key language there talks about the demand requirement. The court says, "We know nothing of these matters save as disclosed in the record, and refer to them only to vindicate the wisdom of the law, which requires that a demand be made upon authorities before the city is forced into litigation. Both upon reason and authority, we are of the opinion that the rule which protects private corporations from suits of this character applies to municipal corporations." Now, if the court stopped there, I would be agreeing with the appellants on this issue, but the court didn't stop there. What it said is, of course, as we shall see, when there is fraud or the threatened action is ultra vires, the rule does not apply. Goldston cited that for the proposition that you can challenge the unconstitutional or unlawful use of public funds to your detriment. Goldston goes through our precedent starting with the 19th century, where we've said we've always recognized the right of a citizen or a taxpayer to say to the government, you took my money and you used it unconstitutionally. Daughters of the Confederacy, as I said earlier, states this as a two-part test in the end of paragraph 35. You either sue on behalf of the city or the county, or you accuse public officials of misuse or misappropriation of public funds. That's exactly what we've done here. We've said appropriating public funds to an Arizona corporation to run red light cameras violates Article 9, Section 7 of the state constitution. You can't do that. That's illegal. We want an injunction preventing you from spending that money. We'd like our money back because you took our money fraudulently, ultra vires, unconstitutionally, whatever label you want to put on that. If the Constitution doesn't grant you the authority to do it, you never had the authority to take our money, and it's still our money. That's why it's slightly different than just your generic taxpayer suit, because in a taxpayer suit, you're not questioning whether or not the government has the authority to raise revenue. You're not saying, well, you couldn't raise these taxes. What you're saying is you couldn't actually apply these taxes as you said that you would apply them. The funding mechanisms here are all interrelated. If you look at the agreement between American Traffic Solutions and the City of Greenville and the Board of Education, it's interdependent on this funding mechanism, the interlocal agreement, all of that comes together. So if you say Pitt County can't pay ATS, the Arizona corporation, then there's no enforcement mechanism. The program all stops. Unlike in a tax case where you'd still have the ability to raise that revenue, you just need to appropriate it in some other way. I see my time's about to expire. Thank you, Your Honors. I would urge you to affirm the North Carolina Court of Appeals decision in this case.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. Very briefly, I want to mention on the summary judgment standard, Justice Newby, you were asking about, this issue was decided at the trial court on a 12B6 motion, not on a summary judgment motion. Our 12B6 on this fines and forfeiture claim was granted. So at the very least, I think the court has to say that the Court of Appeals erred in directing the trial court to enter a summary judgment. With respect to the arguments here today, I think it's clear that what the plaintiffs are really arguing here, really challenging, is how the school board is spending its money. That was very clear from their argument that they're saying the school board doesn't have a right to spend their money in this way. Well, the General Assembly says they do. And the school board is entitled to some deference here. The question that they're raising is, can the school board spend this money without violating the fines and forfeiture clause? The fines and forfeiture clause says that they have to spend the money for the advancement of public education, maintaining free public schools. Question is, does a system in which they get $2.5 million over a couple years advance public education? Does that help maintain free public schools? It would be absurd to say that it doesn't. Imagine a plaintiff coming in and saying, I'm sorry, school board, you cannot hold a bake sale. That's not educational. You can't spend your money on a fundraiser. You can't have a bake sale. That's unconstitutional. This is a version of that. This is a fundraising mechanism specifically authorized by the General Assembly that has increased public funding for the Pitt County Board of Education by millions of dollars, and it's a model for how it should be run. You asked a couple questions about how other people do it. More municipalities might want to go this route and do this program, which would increase funding across the state for education in North Carolina. It would be a boon to education in North Carolina to allow this type of arrangement specifically authorized by the General Assembly here. It would increase public education.
Thank
Reversing the court
you,
would
counsel.
hurt public education. Thank you.